due in no small part to the leadership of our founding chair, Cesar, which was with us a few seconds ago, and the effort of our tireless fellows, many of which are here, and many others which are working hard behind the scenes. Thank you to each and every one of you. Erica, let me say it's a privilege to co-moderate this event with you. Thank you as well for taking lead on formatting this event, and I hope it's a fruitful event for everyone.
Thank you. Thank you, Cesar. Thank you, Daniel. And thank you to the panelists and to everyone who's joining us. Daniel and I, when we were planning, we remembered being at Baker McKenzie, and it's amazing how time flies. And it's so lovely to see everyone. I hope everyone's safe and healthy. I wish we were together in person. But candidly, it might have been hard to organize people from all over the way that we have assembled if we weren't on the webinar. So I guess we take our lemonade from our lemons the way we can. With that being said, it is my privilege and honor. Anyone who knows me knows I love Brazil, I love arbitration, and what better way than to have you guys together here. I have been beyond impressed with what Cesar and the rest of the Brazilian branch has done in just under a year. They have one of the most active branches I've ever seen, and there's literally multiple events on each and every day. And so if anything, I hope that you keep it up. I'm here to support, and I'm really, really delighted to be a part of this. Without further ado, we have a very, very exciting program today, thorough. We're going to do our best to get through everything. I'm going to introduce our distinguished speakers, and please forgive me, in the interest of time, I will do a very short introduction, but I invite you to look everyone up a little bit more at your leisure. So first, Ana Gerdau de Borja. She's an attorney with Derain Garabi in Paris. Anna will be giving us a European perspective, recent developments. She'll be speaking a little bit about class arbitration and group of companies. Next, we have Joaquim Muniz, who is a partner at Trench Rossi, affiliated with Baker McKenzie. Joaquim is also the author of Arbitration of Brazil Procedure, the new version I have, autographed, thank you. Joaquim will be speaking about force majeure and hardship as it pertains to Brazil and Brazilian contracts. Very timely topic. We are also joined by Cristina Mastrobono, who's a former public prosecutor and former deputy attorney general. She's held a lot of very high posts. She will be speaking to us about public entities and arbitration, another very, very important topic. We are joined by Mauricio Gom, partner and founder of GST LLP. Mauricio splits his time between Miami and Brazil and is pretty much usually on a plane. He's right now probably the longest he's ever been sitting. Mauricio will give us an update on current developments in Brazil, in arbitration, and the STJ. Next, Patricia Kobayashi, who is the Secretary General of CAMC-CBC. It's been a pleasure to watch everything that this CAMC-CBC has been doing. The amount of arbitration that has been taking place over the last few years is just incredible, and Patricia's been at the forefront for most of it. And last, but certainly not least, our dear, dear colleague from London, Federico Singaraja, who is a barrister and an arbitrator from London, from Hardwick. He will give us some perspectives from the UK, international perspectives with respect to arbitration, and without further ado, we will commence with the program. So, from the inception of the arbitration law in 1996 to the revision in 2015, with the New York Convention being ratified in 2002, we now find ourselves in 2020. And for those who aren't sure, today is Thursday. In 2020, we've seen Brazil rise in terms of arbitration pretty much like no other jurisdiction. It has one of the most active arbitration dockets, shall we say. And what I was hoping was, Mauricio, if you could give us a snapshot in terms of the current developments. I know a lot has been going on and it's hard to necessarily distill just one or two things, but I would love for you to share with us what you've been seeing in terms of the current developments in arbitration in Brazil.
Okay, good morning, Erica. First of all, I echo Daniel's and Erica's words regarding the role of CIArb in Brazil. It's been an amazing year in the discussion and promotion of arbitration in Brazil and elsewhere. When I was invited to discuss or to propose a topic for this event, and given the international approach of this event, I decided to offer the role of the STJ. And to me, because I am more or less everywhere all the time, I feel sometimes some perceptions from outside Brazil about the current situation or development of arbitration in Brazil. So the topic is, of course, quite open, extremely open, but I'm going to be focused more on the role of the STJ. Before doing so, let me just share with you all some of the important developments of arbitration in Brazil. First, we all, as Erica has mentioned, have to understand that Brazil has moved from the childhood to adulthood in just around 2 decades, and has already become a powerhouse in international arbitration. And why is that? And there are reasons for this. And I'm going to select 4 reasons. One is, of course, the adoption of the arbitration legal regime, or the new arbitration legal regime in 1996, which was amended in 2015. That arbitration legal regime was followed the ancestral model law, which was a very important message to international community that the black letter of the law followed international consensus. Second reason is the increase of judicial acceptance, and more importantly, judicial understanding of arbitration, of local domestic arbitration and international arbitration. By the way, there are specific courts in Brazil which are specialized in arbitration. And the judges who run those courts have become highly experts or specialized in the matter. Third reason, the development of a reliable and steady network of arbitral institutions in the country. And we have here with us today Patricia Kobayashi, who is the Secretary General of the CIArb, the largest arbitral institution in Brazil. So CIArb has staff, facility, work of art facilities, etc. So this creates also some confidence to local and foreign players in international arbitration. And finally, the growing expertise among Brazil's practitioners, scholars, arbitrators, and the students. All this, putting all this into context, has created a steady development of arbitration in Brazil in just about over 2 decades. My focus here is on reason number 2, the role of the judicial arm in the development of arbitration, more specifically, the role of the STJ. As I mentioned 2 decades ago, what was important for our country was to show a good arbitration legal regime, the black letter of the law, the ratification of main international conventions, mainly the New York Convention. Not anymore. Today, all eyes are facing the courts. And as far as Brazil is concerned, that court is the STJ. And there is also a couple of reasons for that. First, the Brazilian Arbitration Act has not adopted a legal or adopted a dual regime, i.e. one that deals with international arbitration and domestic arbitration. Brazilian arbitration law, Brazilian Arbitration Act deals with international and domestic arbitration. Actually, it does not define international arbitration. However, it does define what an arbitral award is. And the arbitral award, according to section 34 or article 34, sole paragraph in Brazilian parlance, says a foreign award is an award rendered outside Brazilian territory. Conversely, a foreign award is an award rendered outside Brazil. So it's a geographical and objective approach. According to Brazilian law, an arbitral decision rendered outside Brazil is considered to be foreign, regardless, and an arbitral award rendered in Brazil is considered to be domestic, regardless of the nationality of the parties, the international importance for the commerce, or the subject matter of the case related to different jurisdiction. It's a domestic award. Having put this into context, so why the STJ is important? Because if the award is a foreign one, the one which is rendered outside Brazil, and there is no voluntary compliance, the losing party has only assets in Brazil, the winning party has to go to Brazil in order to have this award recognized and then enforced. And the court that hears requests for recognition of foreign award is also foreign judgment as well, is the STJ. The STJ, therefore, is the port of entry of all arbitral awards seated outside Brazil. And the STJ, therefore, is key in delivering an important message for the international community, i.e. to foreign investors. Foreign investors, if I may, would give him or them a suggestion, please have a look, follow what the STJ is deciding. And because investors, as we all know, do not enter, do not invest in a country, do not open the front door without looking, without seeing where the exit door is. So you have to show where the front door is and the exit door is. And STJ is showing those two doors in a very pro-arbitration approach. So this is my comment regarding foreign award. Now, comment regarding domestic cases. The STJ is also very important for domestic cases. Within Brazilian judicial system, the STJ is the highest court in matters related to federal law. And Brazilian Arbitration Act is a federal law. For this purpose, Brazilian Constitution is not considered to be a federal law because there is one specific court, which is the Supreme Court, that deals with constitutional issues. So all this, since the STJ deals with federal law, all cases seated in Brazil will receive the last word from the STJ. And STJ, so last word in terms of any judicial related matters, setting aside awards, interference with arbitration proceedings, then may go, or can go to STJ. So STJ has also a very important role when the cases are seated in Brazil. By the way, the STJ has paved the road for the amendment of the Brazilian Arbitration Act into 2015 amendment, when the law, the legal regime has now accepted the public entities, state and state-owned entities, to enter into agreements calling for arbitration. With those comments, those introductory comments, Erica and Daniel, I'm going to stop here. And if time permitting, I will give some other comments regarding those two issues. Thank you.
Thank you, Mauricio. Speaking of public entities and arbitration, this is in Brazil a very vibrant market lately. And I'd like to ask Cristina, Cristina to weigh in on what is the status of arbitration with governmental contracts and governmental entities in Brazil. How is that going?
Well, hi to everyone. It's a pleasure to take part of this event. Well, really, arbitration with public entities in Brazil has been a big subject matter of discussion in the late years, yes. The first thing I have to tell about it is that Brazil did not sign the Washington Convention. Therefore, even the country has signed a lot of BITs, more than 15. There's no really possibility to use the investment arbitration with the country. and public entities are also under the Federal Arbitration Act that, as Mauricio said, regulates the commercial arbitration, domestic commercial arbitration, and also international ones for Brazilian companies and entities. Well, there was really a discussion about the possibility of public entities to use arbitration. And this, well, all the discussion faded with the amendment in 2015 because the reform made explicit that state entities may submit their disputes to arbitration procedures. So before that, there were already some legislation to specific type of contracts like concessions, PPPs, that already authorized its use. So the discussion was a kind of more in doctrinal level than in the practice. There were also some contracts with resources from multilateral financial institutions that had the arbitration agreement due to imposition of these financial institutions. So, but on the other hand, only with the enactment of the amendment of the Arbitration Act in 2015, the governmental officials felt more safe to use the arbitration. Well, what we feel is that there is a considerable volume in disputes involving public entities. I have a data from CAMSI-CBC informing that more than 25% of the amount in dispute in the chamber refers to proceedings in which one of the parties is a public entity. So although the number of proceedings is not so big, the volume in dispute is really high. So, and this is because the use of the arbitration agreement is directly related to the use of concession and PPPs. So Brazil has a big gap in infrastructure, and therefore all the government in all levels have a really great portfolio of projects that are being structured. Now, of course, with the pandemic, with the COVID, there is a hold on those structuring. But we have the expectation of a lot of concession contracts in the next years, and all these contracts will have arbitration agreement also as a mean to attract foreign investors. So not only arbitration is used, but also mediation and dispute boards. So there's really a big increasing, a big development also related to public entities using arbitration. So that's what I would have to say for now. Thank you.
Thank you very much, Christina. When we talk about arbitration in public entities in Brazil, it's hard to ignore the Petrobras case and involvement of the federal union. And I'd like to direct the question now to Ana, because of the Petrobras case and the class action within arbitration that has become. Could you speak to us a little bit about class arbitration in Brazil, and how is that developing?
Hi, Danielle.
Hi.
First of all, I would like to thank Cesar for the invitation and our very talented moderators, Danielle and Erica. So to respond to your question, there is this recent case, there was a decision in February 2020, so this year, by the Superior Court of Justice, that does not represent, in my opinion, the whole bulk of decisions supporting consent to arbitrate in relation to public entities and also of
Anna,
controlling shareholders.
if I can interrupt you a little bit, your microphone is going back and forth. So if I can interrupt you just a little bit.
Can you hear me now?
I think so.
Okay, so you mentioned the case, the Superior Court of Justice case that was decided in February this year. This was a case where in a partial award, the arbitral tribunal sort of decided to refer the federal union, i.e. Brazil, to arbitration on the basis of Article 58 of Petrobras bylaws, providing for arbitration in relation to disputes involving shareholders and the company. And this award was again before the Superior Court of Justice in a conflicts of jurisdiction proceeding. It's a very specific type of proceeding. There was, and in these proceedings, the Superior Court of Justice decided that sort of quashed the partial award, saying in the prevailing opinion that it was not possible to make the federal union severally liable together with the company for Petrobras mismanagement or false disclosure as revealed in the car wash investigation. But this is like this is the opinion of the prevailing justice, that Justice Salomão. But in my opinion, this is an isolated decision, and actually the dissent of Justice Andrighi, it's much more consistent with the whole bulk of case law of all different courts of appeal in the whole country that normally would affirm and would refer to arbitration public entities and on the basis of very, very clear arbitral clause. And also this decision is being criticized by corporate lawyers because in the support of the liability of the controlling shareholder. So this is relates also to, interestingly, it's very fascinating because it relates to a class arbitration. And in moving to class arbitration, that this has been very much developing in Brazil, including in relation to publicly traded companies such as Petrobras and the insurance company CIArb. There's been recently a class arbitration instituted against CIArb and this year. And also there have been a few instituted against Petrobras by minority shareholders, together with very large pension funds that joined the proceedings. And this is ongoing. And there is a particular decision, very good decision by first instance São Paulo judge that was faced with, had this public civil action that instituted by an association of minority shareholders of Petrobras. And this judge told the association, excuse me, there is an arbitration agreement in Article 58 of Petrobras bylaws. You're bound to arbitrate, go to arbitration, and end of the matter. So this, and you can, and plus the judge said, you can't use the association as a shield against the arbitration agreement. So it referred this association back to arbitration, and this association of minority shareholders instituted class arbitration against Petrobras. So it's a very much in high development, class arbitration in Brazil. It's interesting because in the US, with respect to publicly traded companies, there are restrictions to class arbitration, although the United States is very sort of in terms of pioneer in class arbitration, because you have precedents from the Supreme Court, such as Greentree and Stolt-Nielsen. Greentree on insurance contracts, multi-contract insurance, and also Stolt-Nielsen based on charter party agreements. So this is very, like, for certain, the US is like a pioneer in class arbitration, but with respect to publicly traded companies, there are restrictions because there is statutory rights to class action to shareholders of publicly traded companies. So then sometimes there are restrictions to class arbitration. In these are, however, in Brazil, as you see, even for publicly traded companies, you can have access to class arbitration depending on the contract, of course. And well, and so I am mindful of time. I end here. Thank you for your patience.
Thank you very much, Anna, for your perspectives. And the issue of class action arbitrations is not an easy one in any country. We particularly feel that in the US. And it's interesting to watch the developments, and we'll continue to stay tuned. I want to jump over to Fred, if you could give us some perspectives that you're seeing from London, from the UK. As a practicing barrister in England, what types of parallels are you seeing with respect to the two jurisdictions?
Thanks, Erica, and I echo my colleagues' words of thanks to CISA and the organizers of the event. Yeah, I mean, there is a lot of differences between the common English law and the civil Brazilian system, and that also translates into arbitration. But having said that, there's also a lot of similarities. To take something a little bit topical, I suppose, in England, we're currently waiting for a judgment from the Supreme Court in the case of Halliburton and Chubb. That case concerned the Deepwater Horizon case, which some people may be familiar, even non-lawyers, because of the film that was made. So at the moment, that case, and I'll go into a hypothetical scenario in a moment, but there are similar facts and similar things going on in Brazil. I know of at least one case which is currently in the São Paulo court, and the facts are almost identical, and that's also an insurance case. It's LH and Alpa. Now, because these two cases are still ongoing, then let me make up a hypothetical scenario, but based on true life events, if I can be given the indulgence. So I'm going to tell you a story, and it's a story about an arbitrator. For ease, I'm going to call him Bob. So Bob is an arbitrator, and he is appointed onto an arbitration as the chair of that arbitration. He's appointed by the arbitral institution. That arbitration involves A, the applicant, and B, the respondent in the arbitration. There is a subsequent arbitration down the line, and R, the respondent, also appoints Bob as the arbitrator in that, as a party-appointed arbitrator in that arbitration. So you've got arbitration A, which starts over here, which Bob is appointed by the institution as a chair, and further down the line in time, we have a party in arbitration A appointing Bob as the arbitrator down there. Now, those two arbitrations have overlapping issues, and only one of those parties is common to both arbitrations A and B. Now, Bob, when he's appointed by the party into arbitration B, discloses his involvement in the first original arbitration to the party and says, you know, here are potential conflicts. It's up to you to make a decision. But what he doesn't do is he doesn't make a similar disclosure to the original arbitration, which had already commenced. So two issues arise from that. The first one is whether the common party gains an advantage for having one arbitrator in both arbitrations. And the second point is, are there any potential conflicts of interest? And was Bob under a duty to disclose not only to the second arbitration, arbitration B, but also arbitration A? And the thing that sort of comes out of all this, the way it's been certainly framed here in England and also in Brazil, is the issue of unconscious bias. Is there some kind of advantage to being able to see how an arbitrator reacts to certain arguments being put and how they deal with certain issues, remembering that there are issues in common, so that they can then alter their strategy for this subsequent arbitration. And the fact that only one of the parties is common to those two arbitrations means that one party gains an advantage to which the other party in the other arbitrations are completely ignorant of. So I should just take this a step further and say that there is a difference in the statutory obligations in both of those jurisdictions, England and Brazil, down to the curial law of the seat. So first of all, under the Brazilian Arbitration Act, there is a positive duty for disclosure imposed by Article 14.1 of the Brazilian arbitration law. But if you read that quite literally, that provision, the duty is to disclose any potential conflicts before accepting an appointment. In England, we don't have any such statutory duty at all. We do have, however, a test which arises from Article 24.1 or Section 24.1 in England of the Arbitration Act here, and we use that to assess retrospectively whether or not an arbitrator should have disclosed any potential conflicts. That test arises from a case called McGill and Porter. It's widely used and adapted, especially in the Chartered Institute training, and there is some kind of incarnation of that test in most jurisdictions across the world. And the test is about a fair-minded and informed observer. What would they think? Would that give rise to justifiable doubts as to the arbitrator, in this case, Bob's impartiality? So there isn't that statutory duty. In the Supreme Court, it was argued as to whether or not there is an implied duty, but certainly there are duties in respective professional codes of ethics. The particular arbitrator in the Halliburton case named M would have been subject to certainly the barrister's code of conduct, and institutions like the Chartered Institute of Arbitrators has such guidelines, as well as things like the IBA guidelines, which, albeit a soft law, may or may not come into play. So this is why the primary issue in both cases is central to an organization like the Chartered Institute, and they are indeed an interested party in the Halliburton case. One of the central objects of the Chartered Institute is to promote the best and highest standards for ethics in arbitration. The other interested parties in the Halliburton case are the LCIA, the ICC, and the LMAA. So you can see the importance of the impact that whatever decision the Supreme Court will have, not only in English arbitration, but across the world. I'm sure there'll be people all across the world watching for the judgment quite eagerly. So I'll leave it there for now.
Thank you very much, Fred. That was a fascinating presentation on the cases that are going on. And speaking of institutions, we have the privilege of speaking to Patricia Kobayashi from CAMP-CCBC, which I always like to remember is the largest institution of the Southern Hemisphere of the world. I've done that. I've checked that. I've looked at the Southern Hemisphere, and I can't find another institution under the equator that is as large as the CCBC, which actually has a lion's share of the Brazilian arbitration market, and certainly a lion's share of the Brazilian arbitration market within the realm of international arbitration. What I'd like to ask you, Patricia, is could you we're going through some strange times. Going through this pandemic crisis, and that certainly impacted the practice of arbitration worldwide. How has the CAMP-CCBC adapted to the pandemic, and what's the experience of administering proceedings during this crisis?
Well, thank you, Daniel. Well, first, I'd like to thank Cesar Pereira and the Brazilian branch of the Chartered Institute of Arbitrators for the invitation and for organizing this webinar. It is a privilege and an honor to discuss arbitration in Brazil alongside such brilliant and dear friends. So thank you again, Daniel and Erica, for coordinating this panel. Well, when the pandemic reached us and our daily activities, we had to act fast. So did all arbitral institutions here in Brazil and around the world. As many of you may know, most of the arbitration proceedings were still conducted partially with the exchange of physical copies of documents, and of course, in-person hearings. Therefore, a substantial part of the ongoing arbitration had to be adapted to guarantee secure and adequate proceedings through electronic filings, virtual hearings, and overall online case management. So an emergency contingency plan had to put in place, and that was overnight. A CIArb was in 48 hours, to be more specific, to guarantee the safety of our employees and the continuity of our work. What most people don't know is that fortunately, we had realized during this analysis that we had no true obstacles to overcome in terms of our rules. And we actually did have the necessary tools to keep up the work of managing the proceedings during this time. So CIArb published 2 administrative resolutions, which provided for the organization of the center and rules for the electronic processing of the proceedings. Administrative Resolution number 39, 2020, which was the first one, the emergency one in 48 hours. And after that, after April 1st, the 40, 2020, Administrative Resolution 40, 2020. And likewise, all arbitral institutions in Brazil, they acted in the same manner. So the Arbitration Center from the Federation of Industries of the State of São Paulo, the Getúlio Vargas Foundation, CIArb, CBMA, the Market Arbitration Center, and also AmCham, which are all arbitral institutions in Brazil, the most reputed ones, and we are actually acting in a coordinated and friendly manner, exchanging experiences in this time of crisis. As for the challenges, I would like to address 2 of them that we actually faced in this period. The first one was the suspensions we had to determine in a few proceedings, and the second one, the one we are all talking about, the virtual hearings. Well, as for the suspensions, we had, at the time, we had to close our offices about 320 ongoing proceedings. And the first great challenge we faced relates to those cases that respondents' very first notification or their response were still pending. So it was a delicate time in the proceeding. In 17 cases, the CIAmc-CBC had to suspend the proceedings in the first moment for the 39/2020 administrative resolution. And then with the extension of the social isolation measures and the approval of administrative resolution 40/2020, what we have registered is that those proceedings were able to resume, all of them, except one, that this single one that is still suspended, which from my perspective, is pretty successful in the scenario we're living in. As for the hearings, CIAmc-CBC nowadays posted already 30 hearings. So half of them are those to the execution of the terms of reference, which is a virtual hearing per se, regularly done by conference call or just by exchanging emails. And the other ones, those are hearings for the presentation of cases, 3 of them, 3 hearings to deal with emergency measures, 7 hearings, evidentiary hearings or hearings on the merits, and 1 conciliations. As Mauricio has asked me 2 days ago if those proceedings had foreign parties, I was able to count at least 4 or 5 proceedings with South Korean parties, American parties, and French parties, specifically. But anyways, the really interesting part of analyzing these numbers is that according to the discussions that the specialists are having nowadays, we did register some kind of objection from parties to proceed with the virtual hearing. To be more specific, in 6 cases. Some of them we already hosted, and some of them are still scheduled for the next few weeks or months. And even in some cases, we saw objections from both parties, and the arbitral tribunal decided to proceed anyways. So in this extreme case, both parties presented objections, and if I'm not mistaken, it was a case for a hearing for the case presentation. It was not an evidentiary hearing. So we had particulars in the case that, according to the arbitral tribunal perspective, that would not be harmed enough to be hosted in a virtual setting. The requests for in-person hearings were all grounded in the inability of the parties to reasonably present their case in a virtual setting. Counsels relied on the lack of accessibility to reliable IT facilities, for example, or some other limitations, as we have been discussing a lot these days. Even that the counsels wouldn't be able to be in the same room. That was one argument presented. But the main one was the worry that the arbitral tribunal wouldn't have the full comprehension of the case in a virtual hearing. Well, in the end, the particulars of the case and the impossibility of estimating when an in-person hearing will be able or be feasible or safe enough to be hosted have determined the result of the case. Besides those cases, and I'm not sure if I'm extending in my time, but besides those cases, 3 cases are still pending further evaluation. 4 cases are still waiting for the return of presential activities at CAMC-CBC. And in all those 4 cases, both parties have agreed to postpone the hearing. And as for our perspective in administering those hearings and those cases, it is the duty of an arbitral institution to provide the support and the full transparency of our internal proceedings, and more importantly, to share our experiences and the experiences we had with the hearings before. And that's why we have launched notes on virtual hearings and meetings some weeks after the pandemic crisis started, with the experience we've had with such hearings, and explaining to the arbitrators and the parties what kind of service the CAMC-CBC provided and support they had during the hearings, and some details that might guarantee full efficiency of the virtual hearing. I suppose I have covered this first main challenges, but I think a good conclusion would be that parties, arbitrators, and arbitral institutions, they have adapted surprisingly well to the new tools and the new technologies.
Thank you, Patricia. I know that you probably more than any of us have been really faced with having to adapt, and it's not an easy task. And I know that the challenges you're facing, a lot of other people are facing in arbitration in terms of navigating virtual hearing security, and I commend you on everything that you're doing at CAMC-CBC. I know it's not an easy task, and you're doing marvelously well. It is not easy in the time of COVID. Now that we know that this is going to be a longer time in terms of lockdown, we're seeing a difference, right? We had a temporary suspension. Now parties are weighing their options. And as arbitrators, we really have to be sensitive to the parties' needs and wants, but also have to protect the rule of law. And so it's a hard balancing act. And again, you want to protect the integrity of the ultimate enforceability of the award. So it's not an easy juggling act or balancing act by any means. Speaking of our current situation in terms of COVID-19, I surmise that I'm not alone in seeing a lot of requests and advice sought with respect to force majeure and hardship. Businesses are suffering, they're having hard times, and many of them have arbitration clauses. And I was wondering if Joachim could give us some insights in terms of what he's seeing as the main issues that are arising after the outbreak of COVID-19.
Thank you, Erica. Thank you, Daniel. Special thanks to Cesar for the invitation. It's a pleasure to be in such talented panel. My arbitration practice is based pretty much on foreign investments in Brazil, and Brazilian investments abroad. So normally it's a cross-border situation. And what I'm seeing right now, that most of the case, there's a huge demand for arbitrations at this moment because the COVID-19 crisis on its economic effects on contracts. Like I'm a law and economics lawyer, and economic problems give rise to judicial disputes. And you see a lot of all the restrictions that were imposed in Brazil and elsewhere limit the ability of the parties to perform the agreement. And of course, everyone is short of money, so it's very difficult to make payments. So I would say that the amount of work has increased a lot on parties trying to review contracts based on force majeure and excessive burden, how to be translation would be hardship, and that's the difficult thing. Some legal terms are very difficult to translate because they are not the same. And being a lawyer that gives most advice to English and US clients, it's very, they find it hard to understand our legal system, how those institutes work. So that's why I had the idea to discuss them here. Some of the criticisms that we have on our legal system, I would say there are cultural differences. Like when you do a business under Brazilian law, have a contract under Brazilian law, you have to bear in mind that we are a civil law country, not a common law country. And basically you have statutes regulating almost everything. Like the first thing I was preparing here, I have my book here, the Civil Code, because it's very extensive statutory. There are very extensive statutory rules that apply to contracts. And to make things worse, there are very principles of law that prevails over the written rules. So it's very important for non-Brazilian parties to understand Brazilian law when they have contracts subject to legislation. Otherwise, they'll have the inaccurate expectations. And nowadays, the two largest point of discussions are force majeure and excessive burden hardship. And I'll quickly explain how those institutes different from Brazilian law and other jurisdictions. First, force majeure. Force majeure are addressed in the Brazilian Civil Code, and it's defined as a fortuitous event that cannot be avoided or presented, and it prevents the performance of the agreement. So, so when you have a force majeure event, is an event that you cannot prevent, the parties could not prevent or avoid, and you cannot perform the obligation. And what's the consequence of under Brazilian law? You are not liable for damage for not complying with the agreement, for not performing. That's the black letter of our law, and it doesn't need to be written in the agreement. So a non-Brazilian party, if nothing is written in an agreement of force majeure, still those provisions apply. So the debtor will be excused from performance if the cause of non-performance is due to a fact that cannot be avoided. And unfortunately or fortunately, COVID-19 crisis is clearly a force majeure event under Brazilian law. So it could justify non-performance of the agreement. One thing that's very important to bear in mind, like the consequence of force majeure is not contract review. The consequence of force, because many lawyers that are not very technical start claiming, and as an arbitrator I see that a lot, start claiming like force majeure to review the value of the agreement. No, that's wrong. The legal consequence under Brazilian law is non-performance. It's not termination. It's not contract review. It's non-performance for the period of force majeure. And even we have a law that was recently enacted the special and transitory regime that set out the period of the pandemic from March 20 until there's a decree that terminates the pandemic. So probably our case law will see that the force majeure event will only be applicable to this period of time. So what clients that are used to English law or New York law, and I for this I read this, there's this Queen Mary research on 2010 of the most popular law. And congratulations, Federico, it's English law. Like 40% of international contracts are subject to English law, 25% to New York law. Congratulations, Erica. And so people have those law in mind. But if they are subject to Brazilian law, they will have to be aware that the debtor will be prevented from performance if the fact for COVID-19 make the contract. To end force majeure, the two usual things that have to bear in mind first. You see in contracts under English law, New York law, saying like force majeure, it's war, riot, strike, etc., etc., etc. If it's really illustrative, under Brazilian law, it's are those things, and whatever it's above it's what's impossible to prevent. So there will probably be understood under Brazilian law as just examples. So don't read the agreement and say, look, it's just war, strike, and no, it's anything, any event that would be beyond the control of the parties. So that brings to the second point, that if you want to exclude issues from force majeure, you have to specifically address in the agreement. So that makes the role of the lawyer even more important. That's bringing me to the second point, even more challenging for non-Brazilian lawyers, is excessive onerosity that could be translated right or wrong, because it's very difficult to translate legal concepts as hardship. We have express provisions under Brazilian civil code that allow review of the contract under certain circumstances. So what's the test for the application of hardship under Brazilian law? Those are articles 317, 478 and 480 of Brazilian civil code. If you have a long-term contract which is due to unforeseeable or unexpected events become excessive onerous to one of the parties, you can bring a lawsuit to review the contract. So we have those tests. First, the contract must be a long-term contract. Second, the fact shall be extraordinary and unforeseeable. And third, you have to show excessive burden, and you have to show that's a contract that is quid pro quo. It's if you have a contract that's clearly aleatory, it cannot be subject to hardship. And it's very common to see those lawsuits in Brazil, and even more common under the COVID-19 crisis. So if you have a contract under Brazilian law and something happens that changes, something that extraordinary and unforeseeable. So it's not like taking an aspirin, like it's a very serious remedy. But if it's extraordinary and unforeseeable, debtor has the right to review the value of its obligation. Therefore, the advice that I have to parties that, and some clients are clearly surprised if they're not knowledgeable of Brazilian law of this possibility, but that's not something unheard. You have a similar provision, for instance, the French civil code and the German civil codes are typical. The origin of excessive onerosity is a French origin, but the wording of our code is inspired by the German code. So in continental Europe, you'll find something like that, and you have to be aware. And what are the ways to address that if you don't want your contract to be reviewed? First, you have to contract out of excessive onerosity, saying like the contract is it is what it is, and the parties are bearing the risk of the contract becoming expensive. The second thing, expressly exclude issues such as inflation, currency exchange valuation, and to show that is you have the word in Latin, alia, like the risk, to show that what happened was one of the risks that were clearly negotiated among the parties. So that's what I have to say for the moment. Thank you for the time.
Thank you so much, Joaquin. That was really helpful. And I do want to underscore the importance of knowing the applicable law and the differences and the interplay, especially when you're dealing with a civil law system like Brazil, where force majeure is codified, hardship also is in play. Contrast that with New York, with common law. I can speak to New York. Unless it's contractually provided for, force majeure will not be available. And so having that understanding is really helpful when you're advising parties, because it's all about the expectation of the parties that will inform potential negotiations, mediations, and or arbitrations and court proceedings. And I think as arbitrators, we're going to be seeing a lot of analyses that are comparative depending on the contracts and the applicable law that is in play. For instance, in terms of the catch-all provisions and things of that sort, anytime you have a catch-all provision scenario in the US, it will be very, very narrowly construed. They apply the principle of ius justum generis. But in any event, I think it's really helpful for us to understand what's available, what's not. And I think another point, and maybe we'll have time to talk about this a little more, is further complicating, we're going to be having people reopening at different times. There will be external and internal pressures for businesses that may or may not be as apparent. And so that will complicate further the analyses and the decisions that we will be facing. Without further ado, I wanted to, in light of COVID, and I know Patricia was giving us a little bit of an overview from the institutional perspective of how you were dealing with the security, virtual hearings, things of that sort. I wondered if you could also just give us an insight into how many cases you're seeing that are COVID related. Are you starting to see an influx of arbitrations and or mediations? What have you been seeing in terms of requests perhaps for extraordinary measures? Have those gone up? Just give us an insight in terms of what you're seeing a little bit more, if you wouldn't mind.
Well, thank you, Erica. For the cases initiated at CAMC-CBC since the beginning of the pandemic, we have actually noticed some interesting particularities. The CAMC-CBC Secretariat analyzed the arbitration cases initiated from mid-March, when we closed our offices, until the beginning of June. And in the first month, this varied from mid-March until mid-April. There was only one case in which the Secretariat actually registered some relation to the COVID distress. And I was actually curious about it because everyone was asking the representatives of the arbitral institutions, how about the COVID-related cases? And the ICC reported in the Brazilian branch of the ICC reported in the beginning of April that it didn't have any cases COVID-related, and also we didn't have any COVID-related cases, and CIArb was the same, and the Federation of Industries were also the same. But as of mid-April, around April 17, we had noticed that from mid-April up until the beginning of June, over half of the arbitration initiated at CAMC-CBC had a more direct relation to the pandemic or the distress caused by the pandemic. If I'm not mistaken, it's a 55% rate of the cases. Most of them refer to power purchase agreements and other supply agreements, and most of them with take or pay provisions. and that was the result that they needed to start a proceeding to review those contracts. And also, interestingly enough, there were also M&A disputes related to the impact of the crisis. More specifically, one that I analyzed a little further, related to the price under negotiation. And one party understood that it was already closed and the price defined, and the other party, the negotiations were not closed and wanted to review the price. And most of them presented a pre-arbitral emergency measure, and most of them was granted or partially granted by judicial courts in Brazil. And also, they had similar claims for economic and financial rebalancing and contract renegotiations. And what we will see is that arbitral tribunals will have to decide on what Joaquin has said, force majeure claims to excuse debtor for performance, and hardship claims to review contractual obligations. And what I can say from the arbitral institution perspective is that objective data, the amount in dispute related to those contracts have no significant difference from the average or historic average we see at CAMC-CBC. So they had an average of 100 million Brazilian reais, which today amounts to $17 million on average. And what I also could say from an institutional perspective, it's what we will see, it's a growing willingness of the parties to engage in negotiations and settlement agreements. So definitely, yeah, we saw that. And in case of failure, parties will try to take advantage of every tool available to guarantee maximum efficiency, because they really need fast results. In terms of, I know my time is ending, but what I would like to share is that arbitral institutions, they were tested in this period. And now their model of administration, what they propose to the market in terms of case management, it pushed arbitral institutions to have a more secure, transparent case management proposal to the market. And that's my perspective for the next few months in terms of arbitral institutions. And one final comment on virtual hearings is that I missed in the first question is that what we will see probably in the future is that virtual hearings, and that is a comment I would like to say to the public. Virtual hearings, we might have to rethink the hearing in a virtual setting to take advantage of this hearing in a different setting and not replicate an in-person hearing in a virtual setting. So what we will see is a change in every aspect of the arbitration caused by this technological wave we're living today. So thank you.
Thank you, Patricia. And I think that's a really good comment too, in terms of this forces us to look at what we're doing, how we're doing it, and what can we do better or differently. And it's not replicating one for the other, but we're taking advantages where we can, right? Making the best of the opportunity. So I do think that's really important. And I think especially in terms of arbitration, we didn't talk about it today and we don't necessarily have time, but taking lessons from the virtual world, from expedited arbitrations, things of that sort, figuring out ways that we can be efficient and also resolve the disputes that are before us. I think in terms of the program that we've had today, we've covered a lot of topics. We're getting close to the end of the program. And so what I wanted to do is invite the co-panelists and or if there are questions from the audience to provide some perspectives. If anyone has any additional insights or questions that they'd like to pose, now would be the time. We welcome you. We can't say we didn't give you some time, even though I apologize, it's not that much time.
Maybe I could start by giving a practical tip for dealing contra, 2 practical tips of dealing with contracts under Brazilian law, the first thing is to bear in mind that it's not just the four corners of the agreement. So you have to be knowledgeable of Brazilian law, especially principles like good faith.
Mm-hmm.
That brings me to the second tip, that be very careful with contract management. Like if someone writes you a letter saying like it's not possible to perform, make sure whether or not it's not possible to perform. If it's not, write back and say it's not. It's you. Yes, you can perform. And so if the other party is writing letters saying that the obligation is too expensive, make sure to put in writing that you are not benefiting and you're not being reached. There are some concepts of good consequence of good faith, like venire contra factum proprium, that can be even deemed to modify the obligations. So if you give a waiver of obligations, make sure to put in writing, like I'm waiving for this time, but this waiver is not forever. And always show good faith, like it's especially if you have to go to injunction in court. So even if you say no in a gentle and in a justified manner. That makes all the difference.
We would hope that everyone would be that way anyway, but I think those are very, very astute points and recommendations. And I think, regardless of the formal consequences of force majeure, hardship, MAC, material adverse change clauses, things of that sort, parties are using them informally for negotiation purposes. And with that in mind, they need to be careful in terms of protecting their future rights as well. And I think that that's also one point I would offer. But I do think that we're going to continue to see these aspects. And the contrast between the different various applicable laws is really important to keep in mind. From the New York perspective, things are very strictly construed. And that in and of itself, unless you've provided for in the contract, it will be very difficult to claim excuse. And so it remains to be seen, but a lot of contractual analysis, and obviously the facts are very important. I don't know if anybody else wants to comment or
I'd like to make a comment before passing the word to Mauricio, just to comment on Joaquin's point. Someone looking into Brazilian law from an outside perspective and reading the black letter rule on excessive onerosity might be scared, as some of our colleagues in Latin America are, when they read the rule in Brazil, because there is an element in the black letter rule of the law, which Joaquin did not address, because it's an element that the courts end up not enforcing. Because if you look at the rule as it is written, in order to show excessive onerosity, you have to show not only the burden on one side, but that the other party unjustly enriches from that exchange. So what happens is the courts end up saying that if there is excessive onerosity on one side, then the performance per se would always cause the unjust enrichment of the other party. So it's an element that is in the black letter rule, but in the when push comes to shove, courts and arbitral tribunal tend to not look at that element. And so don't be scared if you look at it. That's my only 2 cents. Mauricio had something to share with us.
Yes, thank you, Daniel. My additional 2-cent comment would go now at the drafting of arbitration agreement, not those which were already drafted, and we are facing what's happening in all arbitrations before arbitral institution, etc. But from now on. Quick comment on the topics that normally parties, transactional lawyers discuss, deceit. Based on what I've said about the approach of the STJ, I would easily recommend for a foreign party to have Brazil as the seat, one of those main centers in Brazil, São Paulo, Rio, etc. Because if you win the case, you are there already for the enforcement instead of going through the recognition process. So because the courts are very friendly as a whole, of course, there are exceptions, there are cases that we don't like, etc., etc. But as a whole, that is a very friendly approach. Now, perhaps, I wouldn't say the most important point, but a very important point in this moment, the choice of applicable law, or the proper law of the contract, as the English say. So based on Joaquin's comments. So from now on, it's not a matter that I'm going to choose Brazilian law because I know Brazilian law. If you are a transactional lawyer, you have to bear in mind if the law of the other party may be more interesting for the case of your client down the road. So the question now is, when we say we all criticize, we all discuss this midnight clause, etc. Now, midnight clause, from now on, there is no room whatsoever. You have to dedicate, you have to spend very crucial time in drafting, because at the end of the day, if you pick one civil law, jurisdiction law, or common law, may be may go to a different direction. And finally, the choice of the arbitral tribunal. If you pick an arbitral tribunal who is all common law lawyers, even if this is another, and all civil law lawyers, so you have a tendency, you may have a tendency to one direction or another. In closing, the drafting of arbitration clause, arbitration agreement, or the solve resolution clause, because CIArb, as Patricia has mentioned, so CIArb, so it also requires a lot of understanding and caution to avoid what seems to be a good result at the end of the day, because of the badly drafted clause may lead to more conflict than solution.
If I could latching onto your suggestion, if you're really brave, not that I'm suggesting this, but if you're really brave, you can actually think about getting a procedure that, like me and Erica, has dual citizenship, because since Brazil does not have the concept of a seat, and the only thing we're actually interested in is the place where the award is made. In theory, you can have an arbitration that is seated in London, and which the English would understand as an English arbitration, with instructions to the tribunal that the award be rendered in Brazil. If that happens, in Brazil, that award would be considered a national award, and you would not have to go through the SCJ recognition process, which is quite burdensome. I mean, it takes about a couple of years for you to get through that. So if you can avoid it, it's something that you should do. So I'm not that I'm suggesting that, but if it's something that we could think about. I'd like to hand the floor over to Erica so that she can, I think our time is coming to a close. I would like to thank every single one of you guys, Cristina, Patricia, Fred, Ana, Joaquim, Mauricio, Cesar, which isn't here with us, and Erica, which really put some hard work into formatting this into an event. It's an incredible honor and privilege to be able to be on a panel with you guys, and I think the event was a very interesting event for people who are trying to understand Brazilian arbitration. Erica.
Thank you. Thank you to all the panelists. Thank you especially to Cesar for being our fearless leader here and for all the hard work. And Daniel is way too humble and modest. He put in a lot of effort too, and I want to thank you. It's a pleasure to be with you again. And hopefully we can all be together in person at some point soon. But I hope that this was helpful for those that were joining in. Stay tuned, there will be lots more to come. I apologize that we don't have time for questions. We're at the tail end of our program here, but we are all available offline if you should have any further questions. And thank you again to everyone. Really excellent presentations, and take care, stay healthy and safe. Bye.
Thank you guys. Bye-bye.
Thank you. Bye-bye.